Welcome to today's live cast. One question that we have is, why do you need a J1 waiver? So you need a J1 waiver in order to overcome the 2-year home residency requirement. If you come on the J1 visa, you may be subjected to the 2-year home residency rule, and this will help you overcome the 2-year rule of having to return for 2 years. So the J1 waiver allows you to continue to stay in the United States if it gets approved. So there's a variety of different waivers that you could apply for. There's the no objection waiver, but let's say you're a Fulbright scholar, you're not going to generally qualify for no objection waiver. It's very hard to get if you have US government funding, or your country may not be willing to also cooperate in issuing a no objection statement. So then you could look to a hardship waiver. That is if you have exceptional hardship to US citizen spouse or lawful permanent resident spouse, or US citizen child or lawful permanent resident child. And the standard is exceptional hardship. So it's a high standard. These are not easy to win. So we put a lot of work into preparing those cases. Those cases are taking about 2 years to get approved, although recently we got one approved in about 1.5 years. That's the most common type of case that we file in our office. How long are J1 waivers taking? So depends on the J1 waivers. So for no objection waivers, you have to look at 2 factors here. You got Department of State and you got how long it's going to take for your country to also make their determination on issuing a no objection statement. So that whole process, we're seeing anywhere typically from 4 months to 1 year, depending upon how long Department of State is taking and your home country. Hardship waivers, as I mentioned earlier, we're seeing around 2 years, but that's trending downwards. We're hoping to see the downward trend in terms of like faster processing times. Persecution waivers, same thing. Conrad 30 waivers, those are a specific type of waiver for physicians. Let me explain what that is. So if you're a physician, there's 30 spots in each state available to you to work in an underserved area for 3 years in H-1B status. So in that situation, you have to apply at the state, which is the acting interested government agency. That state will make their determination on whether or not you qualify and then forward it on to the Department of State. And then you have to apply for H-1B. So usually that process takes around anywhere from like 4 to 9 months on average. These are all approximate times. Who is eligible to be able to file for a family member, and who's eligible to sponsor? So US citizens and permanent residents are eligible to sponsor for a green card for their relatives, but only certain types of relatives. So let's talk about who's not eligible. So cousins aren't eligible, aunts and uncles are generally not eligible. So if you're a US citizen, you can file for your spouse, your parent, or your child. If you're a green card holder, in that situation, you can file for your spouse, or you can also file for your unmarried child as well. Depending upon if you're a green card holder or a US citizen, the processing times also differ. So for US citizens, if you're filing, for instance, for your spouse or your parent, that's considered an immediate relative. And that means that you don't have to wait for the priority date to become current, which you can find on the visa bulletin. You just have the processing times, which are long in and of itself, anywhere from like 1 to 2 years, depending upon where you're at in the country. If you're, for instance, a permanent resident and you're filing for a spouse or your unmarried child, you have to wait for the priority date to become current. So the way that I look at the priority date is like you are in a line, and the visa bulletin will tell you where you're at in that line. If you look on there and if you'll see C, that means current, that means there's no line. But if there's a date, that gives you an idea of when your priority date will become current. What are some common reasons that a J1 waiver is denied? Generally, it's not demonstrating exceptional hardship. You have to demonstrate that there's enough hardship factors, and when people come to us to try to rehabilitate the case, it's because we're not seeing that exceptional hardship that you need to demonstrate. It's not just mere separation. It is something beyond that. So if you're sad because you're going to miss your spouse, that doesn't rise to the level of exceptional hardship. If you have depression, perhaps. But then we need to back that up. Are you going to see a therapist? Do you have a diagnosis? Failing to document the hardships, failing to demonstrate the hardships, that's where I see failures in cases. We need to demonstrate, if you're working with us, that your hardships are exceptional. Another question I get about that is, what's the one hardship? Well, a lot of times with many people, it's not just one. Most people don't have a spouse that has cancer, but they do have a spouse that may be suffering from depression or anxiety. They may have career hardship. They may have financial hardship. So it's creating a narrative with all of these factors. And when they are all put together, demonstrates that exceptional hardship in the way that we do that is a very detailed legal brief. What happens if a J1 waiver case is not approved? What are the steps to follow? So if a J1 hardship waiver is not approved, there's a variety of things to look at. First of all, you have to make sure you're maintaining lawful status. Assuming that's the case, let's look at what the reason for the denial is. A lot of times when people come to us and they filed on their own or they hired someone else and they want to see if we could help them, we look at what the reason of the denial was. Maybe the hardship just wasn't fleshed out enough. All the hardships weren't delved into. I'm assuming this is a hardship waiver question. Those are the ones that are typically denied. If it's a no objection waiver, maybe you had government funding and you shouldn't have wasted time applying in the first place. And then you should look at a hardship waiver. So I would look at, is there something we can rehabilitate? Was the application prepared well? A lot of times we see that it's not. And we can look at the reasons and see, is it worth refiling? In many situations, you possibly could appeal if it was denied at the USCIS stage, but it's not worth appealing in many situations because most of the appeals are denied. So refiling is an option that we like to look at. I want to thank all of you for joining. By being here, you're bettering yourself. By bettering yourself, you're bettering your family. And by bettering your family, you are bettering the world. You guys are making a huge difference by being in the U.S., making all of the contributions that you are. Not enough people acknowledge the great work that immigrants are doing. If I can just show a little bit of appreciation that I have, I want to do that now. So thank you. All right. Bye for now.